process. While at it, we must again deprecate the process that culminated in the retirement of Honorable Mr. Justice Ono. The process, and we underscore the process, it is the process that has always been the concern of the Nigerian Bar Association, showed a brazen external intrusion and interference in the disciplinary processes of the judiciary in a manner that undermined its independence and, by extension, the rule of law. The process was not only contrary to the provisions of our laws, but also degraded and desecrated the hallowed dignity that attaches to the office of the Chief Justice of Honorable Justice Dr. Ibrahim Tanko Muhammad, CFR. On behalf of the Nigerian Bar Association, I congratulate these new leaders of the bar who have been found worthy by their superiors and peers of wearing the coveted rank of Senior Advocate of Nigeria. You were obviously chosen from the large number of applicants based on your outstanding qualities of, amongst others, intellectual fecundity, hard work, diligence, unparalleled advocacy skills, sense of purpose, consistency, integrity, and not least, humility. As I mentioned during the elevation of your colleagues last year, I include humility amongst the qualifying attributes because sometimes our colleagues of the inner bar tend to forget that the rank of SAN is best worn with and in humility. Humility in general terms exalts the person. In specific terms, humility stands out and elevates a Senior Advocate of Nigeria. To wit, humility to the courts, humility towards your colleagues of the inner and outer bars, humility towards your clients, and indeed humility towards members of the public. It is the humility in you that would oil your words and speeches in a way that makes them soothing and respectful to everyone, not least the courts. It is the humility in you that would persuade you to share your deserved front row seats with members of the outer bar who are not entitled to the front row seats as of rights when you are in courts, but who are unfortunately consigned to stand in a crowded and sometimes stuffy courtroom and wait while you conduct your case because all the seats to which they're entitled are occupied. Humility is actually the hallmark of great men, and you must not forget that fact while adorning your Senior Advocate of Nigeria's rank. Your elevation comes at a time that the profession, both the bar and the bench, is under siege, mostly at the instance of agencies that ordinarily should be our partners in law enforcement. It is no longer news that some law enforcement agencies seem to derive sadistic pleasure in locking up lawyers and imposing impossible bail conditions for their release, mostly in the course of investigating the professional functions of these lawyers. And I underscore, investigating the professional functions of these lawyers. Indeed, the practice of law is now being criminalized by these agencies, all in an effort to demonize and humiliate lawyers and the legal profession. The practice of law has consequently become very dangerous and risky. To illustrate, it used to be the practice that lawyers under investigation, and this was far and in between, by law enforcement agencies were routinely granted administrative bail based on self-recognizance. The NBA has no record that any of those lawyers subsequently refused to honor the invitation of those agencies or absconded in the course of any such investigation. So, what justification is there other than abuse of powers and egotistic humiliation and degradation of lawyers and the legal profession by some law enforcement agencies for the now commonplace imposition of horrendous administrative bail conditions, including the depositing of travel passports consequent upon the investigation of lawyers by these agencies? Do these agencies truly believe that these lawyers, some of whom are senior counsel, will jump self-recognizance administrative bails? No, they do not. They do not so believe, but they are sworn to humiliate and desecrate our profession. In a number of these cases, the lawyers are investigated and so humiliated for carrying out their professional duties and nothing more. I underscore these issues because you all, by your elevation today, are leaders of the bar and have a sworn duty to safeguard and promote the rule of law an indubitable component of which is the independence of the legal profession. That independence is eroded when lawyers have to be choosy in accepting briefs and or instructions solely because they do not want to incur the wrath of any law enforcement agency for performing their professional duties. The society suffers when we descend into that abyss. Access to justice and fair hearing suffers, and this is because persons in need of legal services are not permitted and or enabled to engage the lawyers of their choice. That is the pathway to self-help and anarchy, not to mention the deleterious effect such a descent has on our economy. It behooves us, therefore, as lawyers and leaders of the bar to stand up for the independence of our profession, and by so doing, push back on authoritarianism and malevolent abuse of power. We must, as members of the bar, speak with one voice in this regard, and you, as members of the inner bar, must join the NBA in taking the lead. That said, I must continue to emphasize the imperative for us as lawyers to imbue our everyday conduct and practice with utmost integrity and professionalism. And a lot has been said in this regard by my Lord the Chief Justice and by my senior chief, T.J. Okpoko, and of course the Attorney General of the Federation. And I adopt those issues that have been raised by these eminent personages, including my Lord the Chief Justice. It is not for nothing that ours is referred to as the noble profession. That nobility must show in our uprightness, professionalism, and utmost integrity. We must not by our conduct give cause for denigration and debasement of our profession by detractors and naysayers. To this end, the NBA will be working very shortly with relevant stakeholders in the profession to strengthen our self-regulating internal mechanisms, including enforcement and disciplinary processes, in order to ensure their enhanced robustness, effectiveness, and efficiency in identifying and weeding out the bad eggs, if any, in our midst, while protecting the consumers of legal services. Permit me, my lords, to return to the subject of the judiciary in the context of your lordship's 2019-2020 legal year. It is our prayer and hope that the welfare of our judicial officers at all levels, notably their compensation packages and allowances, would be reviewed and adequately enhanced in this new legal year. Incidentally, I did not have a peep at my Lord's address for me to see that that was mentioned, but of the bar, we believe indeed that it is necessary that the compensation package for judicial officers should be reviewed upwards. We betray our vaunted fight against corruption in the judiciary and public sector when we remunerate our judicial and public officers most inadequately as we currently do. The fight against corruption is best fought by tackling the incentives for corruption, such as the extremely inadequate compensation packages for our judicial and public officers generally. We appeal to relevant stakeholders to holistically review upward the compensation packages of our judicial officers at all levels, sufficient to objectively eliminate any incentive for corruption in the judiciary. At the same time, the judiciary must not relent in ridding itself of corrupt elements, if any, in its fold. The internal self-regulating processes that reside within the NJC, pursuant to law, must be utilized and constantly oiled to weed out corrupt judicial officers who give the judiciary a bad name. The judiciary would, in the process,